Still on the series of defenses, bars to petition for divorce in Nigeria. Why would the court refuse to grant a decree of divorce even after the petitioner must have established that the marriage has broken down irretrievably? Like he or she has proved to the satisfaction of the court that this marriage has broken down irretrievably. If you've been following our series on grounds for dissolution of marriage in Nigeria. Why? That will happen if only there was condonation or connivance or collusion. In my previous video, we had already discussed condonation. If you did not see the video, please kindly go and do so that you would understand better as we move forward. Welcome back to my channel. This is Law Talks and Gist. If you're seeing my face for the first time, thank you for stopping by. Please kindly click on the subscribe button, like, share, comment, and do not forget to turn on the notification bell so as to be notified each time I upload a new video. And if you're a returning subscriber, thank you for always tuning in. Now let's dive into the video. So even after a petitioner must have proved to the satisfaction of the court that this marriage has broken down irretrievably, like we discussed in our previous video, that ordinarily, if some facts exist which would constitute a ground for dissolution of marriage, and it has been established, the court is supposed to grant a decree of divorce. But now, even after all these facts or some of the facts has been established, the court is still reluctant in granting the decree of divorce, then that means something is wrong somewhere, and that is what we are discussing in this video. So previously we said condonation can make a court refuse to grant a decree of divorce, and in today's video we'll be looking at the second absolute bar, which is connivance. When there has been a connivance, the court will refuse to grant a decree of divorce. Now, what is connivance? Connivance is simply where the petitioner has either encouraged, consented, or willingly contributed to the commission of the misconduct on which a petition for divorce is based. I'm going to explain. So here, the court will refuse to grant a decree of divorce on the ground that he or she connived at that misconduct. Connivance operates on the principle of voluntary non-fit injuria. What is that? It is a legal maxim, which means willingness does not make injury. So the whole concept of this legal maxim is that a person who knowingly and voluntarily risk danger cannot recover for any resulting injury. You cannot complain of something you contributed to. What the law is saying here is that, let's take for instance, a husband is bringing a petition for divorce before the court, and then the wife cross petitions and says that, oh, like my husband contributed to this matrimonial misconduct. Whatever the matrimonial misconduct is, like whatever is the ground that he is bringing the petition. Let's take for instance adultery. The husband is bringing a petition based on adultery. And now the wife cross petitions and says, oh, my husband consented, or my husband contributed to this adultery that I committed. And she is able to prove to the satisfaction of the court that truly the husband contributed. If she is able to do that and the court is satisfied that the husband actually contributed or encouraged that act of misconduct, that will amount to connivance. So he cannot now come and use that as a basis for divorce. That is what the whole concept of connivance connotes. Okay, let's use another thing. For instance, your wife drinks and you are the one who takes her to that beer parlor, she drinks excessively, you encourage the act, you take her there, you buy it for her. As she's drinking excessively, you are there watching her, you're not stopping her. And then tomorrow, maybe you bring a petition trying to establish the fact of behavior of the respondent. We have talked about this. So drunkenness falls under behavior of the respondent. You see, you cannot thereafter bring a petition for divorce based on the behavior of your wife. You can't use that as a ground to divorce her, because you already connived by assisting her, by encouraging her, by contributing to that act. So whenever we are talking about connivance, we will not fail to mention the case of Obiagu versus Obiagu. This is an old case where the couple had married for a few years and the wife couldn't bear her husband's children. So what did she do? She advised the husband to go and bring in another woman rather. So this woman came into their matrimonial home and was cohabiting with the husband, was also sleeping with the husband. As a result of that adultery, she bore the husband 4 children. Guess what the wife did? She brought a petition before the court for divorce on the grounds of adultery. And the husband cross-petitioned that she consented. As a matter of fact, she's even the one who advised that the woman comes in and bear children. She's even the one who, in fact, she's even the one who brought in the woman. So the court refused to grant a decree of divorce on the ground that the petitioner, that is the wife, had connived at the respondent's adultery. How can you initiate something and then you later turn to go and petition for a divorce on that ground? It will not work. I hope we understand the concept of connivance. Don't forget, first, condonation, second, connivance, and then the third one is collusion. Collusion has to do with agreement or acting in concert to procure the initiation or prosecution of a suit for divorce with the intent to cause perversion of justice. Please take note of intent. That's intention to cause perversion of justice. This one is going to be self-explanatory. For example, where maybe one of the parties is induced to come and pretend to state certain facts that are not true in a petition for divorce, or where one of the parties, maybe the wife, is even induced to come and present a petition for divorce on the promise of a substantial and lump sum compensation. Say, go and do it. Let's just, maybe her lover or anyone at all. You know how people can just come to court and lie, state certain facts that are not true, just to get divorced so that they will be free, so that whatever reason they may use. But just understand that collusion has to do with acting, just coming to court during a petition for divorce to just act, lie, so that they can just get the petition for divorce and go their separate ways. So if the other party can prove that, oh, this other party is lying, this is not real, this is all acting, this is all made up, then a decree of divorce will not be granted. Please don't forget that these three, condonation, connivance, and collusion, are all absolute bars. We had already talked about what absolute bar is. If it is an absolute bar, the court is going to dismiss the petition. But if it is a discretionary bar, which we are yet to talk about, the court has the discretion to either grant the petition or not grant it. We're going to stop here for today and continue with the discretionary bars in another video. Thank you so much for watching. See you in our next video.